Hi, everyone. We're going to wait just a couple of minutes to get started as folks are still signing on. Thanks. Good afternoon, everyone. This is Hannah Matthews at the Center for Law and Social Policy, and I'm joined by my colleague, Wendy Cervantes. And we are really happy that you were able to join us this afternoon to talk about this very harmful proposed regulation on public charge. We know there have been a lot of webinars and speaking events about this. We are going to gear this webinar towards explaining what the impact of this proposal would be on young children, and in particular what folks in the early childhood field need to know about public charge. Next slide, please. So we'll start by giving a little bit of an overview and just in terms of what is in this proposed rule, what the content is. We'll talk specifically again about the impacts on young children and on early childhood programs. And then we're going to spend time talking about the public comment process. And I'm sure that many of you have submitted public comments before. We're going to talk about what this process specifically looks like and what our request is to all of you as we are working to get a very large number. Our goal is 100,000 unique comments in opposition to this rule. So we'll talk about what that looks like. We will save time at the end for questions, but I encourage all of you to please submit questions to us at any time during the webinar by using the chat box on your screen. So with that, I will turn it over to Wendy and we'll get started with an introduction to public charge.
Thank you, Hannah, and good afternoon to all of you, or good morning, depending on where you are. As Hannah mentioned, I'm going to provide a brief overview of what the public charge policy looks like today and how it would change under this proposed rule. Next slide, please. So what is public charge? It's a term used by U.S. immigration officials to refer to a person who is considered likely to become primarily dependent on the government as their main source of support. The public charge determination is made in two main instances. When an individual is seeking to enter the U.S., such as through a family-based visa, or when they are applying for a green card or lawful permanent resident status. It's very important to remember that there is no public charge test when a green card holder applies to become a naturalized U.S. citizen. However, if a green card holder leaves the U.S. for more than 6 months or 180 days and re-enters, they are subject to the public charge test in order to be able to re-enter. It can also apply in certain instances when an individual is seeking to adjust their visa status, such as someone who's here on a student visa who may be seeking to adjust to a worker visa. It's also important to remember that the public charge test does not apply to all immigrants. Refugees, asylees, special immigrant juveniles, people fleeing domestic violence, and some other groups are not subject to a public charge determination. This exemption is in statute and cannot be changed by regulation. Next slide, please. So the current definition of public charge is very narrow and considers only the use of 2 public benefits: cash assistance for income maintenance, such as through TANF or SSI, and long-term institutional care at government expense. Immigrants who use these benefits could be deemed a public charge, but by law, no single factor determines whether a person is likely to become a public charge. The government must look at an applicant's totality of circumstances to make the determination. Some of the factors they must consider include an individual's age, their health, family status, financial status, education and skills, and what is known as an affidavit of support, which is a binding contract by an immigrant sponsor, usually a family member. Next slide. As many of you know, on October 10th, the government issued a notice of proposed rulemaking on public charge, which was published in the Federal Register. Many advocates have been waiting and preparing for this rule to come out for some time. It came after over a year and a half of false alarms, including a leaked draft executive order from last year and a leaked draft rule this past March. The proposed regulation would change current policy in 3 major ways. It would change the definition of public charge. Second, it would expand the list of public benefits that could make someone a public charge. And it details new negative factors that would be considered under the totality of circumstances test. And we'll break that down for you a little bit more. Next slide. Let's start with the definition. Once again, the current definition of public charge is a person who is likely to become primarily dependent on the government for subsistence or their main source of support, indicating that their main source of support is the government as measured through cash assistance or long-term care at government expense. As proposed, the definition would change to an immigrant who receives 1 or more public benefits. This is a drastic shift, moving away from the concept of a person who primarily relies on the government to someone who may just need to use a public benefit to meet certain needs, even temporarily. Next slide. Second, the proposed rule would also expand the list of benefit programs that could make someone a public charge. In addition to cash assistance like SSI and TANF and long-term care at government expense, it would add the 4 additional types of benefits included here in blue, which are non-emergency Medicaid, SNAP, the Supplemental Nutrition Assistance Program, formerly known as food stamps, housing assistance, and subsidies for prescription drug costs under Medicare Part D. There are exceptions for emergency Medicaid and certain disability services offered in school settings. DHS is also asking for input on inclusion of the Children's Health Insurance Program, but the program is currently not included in the text of the rule. Next slide. Also, the rule states that a program that is not specifically listed in the rule would not make someone a public charge. Examples of programs not included under the rule are listed here, including Head Start, Child Care Assistance, WIC, Early Intervention, the Children's Health Insurance Program, but once again, the government is asking for input on whether or not this program should be included, school breakfast and lunch, public education services, including public pre-K, home visiting, and the others listed here. Next slide. It's also important to remember that only an individual's benefit use would be considered under this proposal, which is different from earlier leaked versions of the proposal that we've seen. Therefore, the use of benefits by U.S. citizen children will not directly be a factor in a parent's public charge test. For immigrant children, however, their own benefit use counts towards their own public charge determination. Next slide. As mentioned, under current law, no single factor, such as benefit use, can determine whether an individual is a public charge. DHS must consider other factors under the totality of circumstances test. The proposed rule adds new specific factors to this test, which make it much harder for low-income and working-class families to pass, regardless of whether or not they have used public benefits. It also now weighs certain factors more heavily than others, with more negative factors than positive ones. Factors include being too old or too young. If applicants are under 18 or over 61 years old, that would count against them. So being a child or a senior would be weighed negatively. Whether applicants have a health condition that could affect their ability to work, attend school, care for themselves, or require expensive care. This would be weighed heavily against applicants if they can't show they have private insurance or resources available to cover that care. Household size. If an applicant has a number of children or other dependent family members, like an aging parent, this could be held against them. The proposal also adds a new income test for the applicant. Earning under 125% of the federal poverty line, or about $31,000 a year for a family of 4, would be weighed negatively. The applicant's credit history or score could also be weighed, along with whether or not they have ever received or applied for a fee waiver when applying for an immigration benefit. Under education and skills, whether the applicant is limited English proficient or speaks languages in addition to English would be a positive factor, and being limited English proficient would be considered a negative factor. And then that affidavit of support from a sponsor is no longer sufficient to overcome other negative factors in this test. It is only one of the many factors that can be considered, and there is more scrutiny placed on sponsors. Next slide. Taking a closer look at children under the totality of circumstances test, once again, being a child or under the age of 18 is a negative factor in a child's own public charge test because they can't work. And children are included in the calculation of household size, which may make it more difficult for parents to meet the income test. Next slide. As mentioned, rather than just list these factors, the rule also weighs the factors. On the right side of the scale are the factors that weigh heavily against individuals, which include a lack of job or job prospects. The rule specifically says it could be weighed against someone if they're not a student, not a full-time student, have no current or recent employment, or no reasonable prospect of future work. Also, having a medical condition that requires extensive treatment and being uninsured or without the financial resources to pay for care is also weighed heavily in the negative side. And also receipt of public benefits, which means current receipt of public benefits or receipt of public benefits within 36 months, but only benefits received after the regulation is final and has a 60-day buffer period before implementation. And then there's really only one heavily weighed positive factor, which is high income, which under the rule is defined as household assets or resources of at least 250% of the federal poverty line, which would be about $63,000 for a family of 4. This is a very high threshold, which one in 3 Americans would actually struggle to pass themselves. Next slide. So let's turn now to an example to show how this proposed rule would play out. Jasmine is a 4-year-old U.S. citizen. Her mother is a graduate student from Mexico who's had DACA, or the Deferred Action for Childhood Arrivals program, status since 2012. Her mother works as a student instructor and research assistant to pay for school, as she's ineligible for any federal loans. Jasmine's father is a U.S. citizen and works as a teaching assistant, earning $30,000 a year. Jasmine and her father both receive Medicaid. Her mother is not eligible and relies on her school clinic to treat her severe asthma. Jasmine's father petitioned for her mother's green card 6 months ago. Next slide. So under the proposed rule, this is how Jasmine's mother's public charge test would play out. The receipt of Medicaid by Jasmine and her father shouldn't be held against her mother in the public charge test. Her mother's age, however, is the only positive factor. On the negative side, the family's low income, their household size, and the mother's health condition would be considered negative factors in the public charge test. Next slide. A few things to keep in mind. First, this is a proposal. Current guidance on public charge remains in effect. The proposal is also not retroactive. Proposed changes would only apply to benefits received after a date in the future, after the rule is finalized, published, and then there's a 60-day period before implementation. So really, there's no benefit for families to disenroll in programs at this time. And also, it's important to keep in mind that the final regulation could look different from what's being currently proposed. This all depends on comments received, potential litigation, and other changes that might be made. And there's also the chance that this rule could never be finalized. So with that, I will turn it over to Hannah to talk more about the impacts of the proposed rule.
Thanks, Wendy. I just want to give a reminder, if there are questions as they come up, please feel free to go ahead and submit them into the chat box, and we will be answering them in the latter part of the call. Next slide. So I think it's pretty clear from the overview that Wendy gave that this is an incredibly punitive regulation, but I just want to underscore some of the most harmful impacts to children and families. The first is that because of those negative factors that Wendy explained, household size, the income threshold, this is a proposal that would make it significantly harder for low-income immigrant parents in particular to obtain long-term residency or to obtain LPR status. We know that children in mixed status families face a number of harmful effects going forward that have to do with the extent to which their family is able to achieve economic stability, has to do with children's mental health and even just stress from living with that instability. We know that children experience tremendous fear at the prospect of being separated from a family, and the idea that adults may be denied green cards and that families could be destabilized and potentially separated can have really detrimental harm to children and families. It's true that with every attack on immigrant communities, we see increased stress among adults and children alike. This is something that CLASP has studied in our own research that came out earlier this year. We know that already just the leaked versions of this rule contributed to parents feeling nervous and uneasy about accessing public benefits, some deciding to already pull out of those programs. And parents will again face difficult decisions about using health and nutrition assistance that will have harmful impacts on their health and their family income. And of course, I don't have to spell out for this audience that children's health and well-being is of course tied to their parents. And so if we see increased sickness, increased stress levels, increased poverty among parents, that matters for children. Now, while that's intuitive to all the folks on this webinar, that is a really important point to drive home in the public comments, as language in the proposed rule attempts to frame this rule as holding children harmless, and yet we know that it absolutely fails on that measure. Just to underscore even more, and so that there's no confusion that this is not our assessment of the harm to families, the words that are on the screen right now, you can see are taken directly from the proposed rule. This is the Department of Homeland Security's own prediction of the harmful outcomes that would come from this rule. We've added the emphasis there in the bolding ourselves, but you can see increased obesity, malnutrition, increased use of emergency rooms, prevalence of communicable diseases, increased poverty, housing instability. All of these are predicted to happen as a result if this proposal were to go forward. Next slide. Now, I also want to underscore a point that you heard from Wendy, which is that early childhood programs, including Head Start, child care assistance, and others, are not included in the proposed rule. That said, we know that parents will be even more reluctant to use public benefits for themselves and their children as a result of this rule, and early childhood programs will be no exception. I referred to the research that CLASP has done earlier. We were already documenting and hearing about declines in enrollment in early childhood programs, children not coming to programs anymore. We are concerned that this will only increase with this rule. One estimate now is putting what we call the chilling effect at up to 26 million individuals. And that is that we know from past experience that when there are changes in immigration law, the impacts are far-reaching, well beyond those who may be directly impacted by the rule, but in fact, due to the complexity of a rule, misunderstanding, and just widespread fear, we conclude that a large number of people would have that chilling effect, and that includes 9 million children. I think it's important for early childhood providers to understand that this could become a reality, and so thinking about what we can do currently to try to reduce that chilling effect is really, really important. Next slide, please. Now again, to keep in mind, this proposed rule is related to a provision in immigration law. It does not change immigrant eligibility for public benefits or early childhood programs. That means that nothing changes at the point of enrollment for early childhood providers. If you're doing intake and enrollment for public benefits, it's really important to know that there is no need to change any practices and that none of the eligibility changes. That said, we know that families will have concerns, and so we are doing what we can, and I'll highlight some resources at the end of the webinar to make sure that early childhood providers have accurate information to share with families to address some of those concerns and hopefully to mitigate the chilling effect to the extent that we're able to. Next slide, please. So I just want to sum up, because in addition to the harm that we are deeply concerned about for individual children and families, this is a proposed rule that is harmful to our country as a whole. It is absolutely an attempt to use a backdoor approach to reducing immigration. It is a radical departure from current immigration law, which is essentially attempts to close our doors to immigrants with less means and favors those who are wealthy. We also know that to the extent that families will not seek health insurance, will not seek nutrition assistance and the supports that they need to keep their families strong, that puts the health and well-being of millions at risk, both in immigrant families and other families. We all live in community. 1 in 4 children lives in an immigrant family in this country, and the impacts on those kids will impact all of us in communities and our country in the future. This will make us a hungrier, a poorer, and a sicker nation. Next slide, please. So let's talk about the public comment process, because this is the opportunity to speak out. Next slide. I want to start by actually saying thank you, because I know that we have, for the last 2 years or so, really asked you all to stand up on a number of different issues related to immigration. And I know that many in the children's community and the children's advocacy community have done this and continue to do so, have been speaking out on family separation and other issues, and really are seeing that all of these changes to immigration policy, in fact, have tremendous impacts on our country's children. So I want to thank you for all that you've done, and thank you again for stepping in to really speak out on this very important issue. Next slide. CLASP and the National Immigration Law Center are co-chairing a campaign called Protecting Immigrant Families, and this is the effort to push back against this threat to children and families. We are thrilled that we now have well over 275 active member organizations in 30 states, a membership that is literally growing daily. And what's important is that the organizations involved represent very diverse groups and sectors. So we have folks from the medical field, health field, nutrition, faith-based groups, lots of coalitions that have come together in states. And together we are all fighting back on this proposal. So you can go to the website there and find more information and resources to make sure that you're a part of all that's going on with the campaign. Next slide, please. The campaign is using what we call a sector-based strategy to develop model comments on this proposed rule. There are comments being developed from well over 30 different sectors, again, written from the perspective of whether it's health or higher education, the impacts on reproductive justice, impacts in particular states. We have lots and lots of different perspectives that are included. CLASP has drafted a template for the early childhood sector. If you haven't seen it yet, we'll make sure that it's emailed to you at the conclusion of this webinar. We don't want you to be confused by receiving multiple comments and multiple templates. The strategy here is to have as many unique comments as possible. So you are welcome to use more than one template, to mix and match templates, but to look at them and choose the arguments that resonate most closely with you. The template is just a guide. We'll talk about this and what those comments can look like, but understand that the federal government is required to read and consider every unique comment it receives. So while our ultimate goal is to have this proposal defeated and to have this proposed rule withdrawn, a very important part of the strategy is overwhelming the administration with public comments that will slow this process down and allow for other advocacy strategies. So that is why the unique comments become very important. We do want you to feel free to distribute the template widely among your network. It is meant to be shared. Next slide. So who should comment? Everyone. Comments can be written from the perspective of individuals and organizations. We hope that you'll do both. If you're writing them on behalf of your own organization, we hope that you'll submit individual comments and ask your spouse and brother and sister and parents and your neighbors to submit comments as well. In programs, comments can be written from teachers, program directors, family support workers, and from parents. It's very important that every individual have an opportunity to comment. Just to flag that submitting public comments to an agency is not considered lobbying, so those that are concerned about their 501c3 tax status should know that this is an advocacy opportunity that you should not hesitate to be involved in. Next slide, please. So what do we mean by a unique comment? It's really important to modify the comment template and to use arguments that you feel most comfortable writing about. When you see the template comment that CLASP has written, you will see lots of text highlighted in yellow, and those are suggestions or prompts for areas that you can use to personalize the comments. So you should feel free to adapt the comments into your own words. You might have examples of state or local data. Maybe it's demographic data on children in your community that would be impacted. Maybe you have data about program enrollment in your early childhood program and how you think this might impact enrollment numbers. Maybe you've already seen declines and want to talk about how immigrant families are experiencing the current policy landscape. Individuals are encouraged to share personal experiences and stories. You might be someone who has used public benefits at a time in your life and can talk about the importance of those programs, the important role that those programs play, not just in meeting the needs of young children and their development, but promoting economic stability and helping people move forward in their lives. Anything that you can think of is totally relevant to include, especially if you can talk about why this matters to you and to your organization. So as I said, in the template comment, you'll see examples of the kinds of things that you might include in your comments. It's important to flag also that this is a very, very large rule. It's several hundred pages long. It's very complex. We do not expect that everybody who is commenting will comment on all aspects of the proposal. That's not intended, and that's part of the purpose of having multiple sector comments. So you should feel free to comment on particular aspects of the proposal that you can speak to and that are important to you. Don't feel like you have to include everything. Next slide, please. Comments must be submitted by December 10th. Those of you who have commented on other federal proposals before will be familiar with regulations.gov. That's the website where you can go in and upload your comments that are likely, if there are a couple of pages, you can upload a PDF file. We also, in encouraging individuals to submit comments, have created a user-friendly portal, and that is found directly on the homepage of the Protecting Immigrant Families website. So if you encourage individuals to comment, they can go directly there, and that comment will be submitted into the Federal Register in a little bit more of a user-friendly way. Next slide, please. So what are some do's and don'ts of commenting? The first thing to remember is that we are looking for comments that oppose the rule in its entirety. Please don't forget to explicitly request that the rule be withdrawn in your comments. You can talk about the elements of it that are bad, but we want to make sure that we're asking overall that this rule be withdrawn and that it is harmful in its entirety. I've talked about the ways that you can think about personalizing your comments, giving examples from programs, from communities, from families. Personal stories are very powerful. And again, all of those comments should be submitted before December 10th. Because we are looking to have the rule completely withdrawn and not finalized, we ask that you do not suggest corrective language. So we are not trying to fix this proposal. It can't be fixed. So that's something to be mindful of in comments. Similarly, we don't want to discuss programs that aren't mentioned in the proposal. So if a program is not currently under the definition of public charge, please don't say, it's so great that you didn't include WIC in public charge. Similarly, please don't necessarily highlight one particular program as being not under that definition. We want to, again, oppose this in its entirety. We can't make this better. And finally, we want to ask you not to sign on to group comments. I know that there have been times in the past that we have sent comments around and encouraged folks to get lots and lots of sign-ons from their networks. This is a different strategy. Again, we want to achieve 100,000 unique comments. So you are welcome to share our model comments with folks in your network and encourage them to submit their own. But please do not get sign-ons and do not sign on to other groups. We want to have everyone, as many people as possible, submit their own comment. Next slide, please. In addition to making sure that that public comment gets submitted by December 10th, we want to make sure that we're taking some additional actions to really help support immigrant families in our communities. So many of you that are in early childhood programs yourselves are that direct line to families. it's really important to educate families about what is in the proposal and what is not in the proposal in order to fight the chilling effect. There are talking points at protectingimmigrantfamilies.org, which are intended for people who may be impacted by the rule directly, so you can certainly look for those and use those. And also, it's a good idea to think about how you might refer individuals to the legal assistance that they need to make decisions for themselves about what they might want to do in the future. Again, it's important to tell people to keep in mind this is a proposal. Nothing has changed. Families should not be taking any actions now to withdraw from public benefits, but we want to make sure that they are getting the help and support that they need. You can also speak out against this proposed rule. We have been having lots of attention on social media using the hashtag #ProtectFamilies. We encourage you to talk on social media about why this proposal is harmful. And finally, we want to really document the impact that this proposal could have on individuals and families who will feel comfortable sharing their story. There's a link there to a story collection that's happening through the Protecting Immigrant Families campaign. And again, we want to make sure that we're getting the story out about how individuals may be impacted directly. Next slide. CLASP has developed, there are a number of resources, I said, on the Protecting Immigrant Families website. CLASP has developed a couple of resources that are intended specifically for the early childhood field. On the left, you can see a Q&A document that is on our website, and we will send, again, as follow-up from this webinar, that really explains for folks that are working in early childhood programs what's in this proposed rule, what's not in the rule, and what the impact might be on programs and on families. And on the right side there is a fact sheet that talks about the impact to children more broadly of this proposal. You are, again, welcome to use any of the research and citations and facts that are in that fact sheet in developing your own comments. We want to make sure that we tell the federal government loud and clear that this proposal is detrimental to children and to our country's future. So I encourage you to submit questions in the chat box, and we will answer them as they come in. Okay, waiting for questions in the chat box if folks have them. One question we tend to get a lot is about the look-back period, given the fact that immigrants' past public benefit use could be used in the public charge determination, and we just want to clarify that even though there is a look-back period, this rule isn't retroactive. So once it does become finalized, like let's say the rule is published and finalized in April of 2019, there would still need to be a 60-day period of implementation, so it wouldn't actually go into effect until
let's see, if it was April 2019, that would be June of 2019 of whatever date it was published. And so that would give people time still to make decisions about whether or not to disenroll in programs. So that's just something we wanted to flag. Although we don't have any really clear idea of how long it will take for government to review the comments and to deal with any other concerns or potential litigation that might come up. So we are, which is one of the reasons why we're also encouraging as many comments as possible to help delay the process.
Shiva, it looks like there might be questions that we can't read. Would you be able to read them to us, please? Sorry, folks. We know there are a couple of questions. We're having a little bit of technical trouble. Okay, one question is whether people can share slides on social media and broadly. Absolutely, we will send out a copy of the presentation and we will send out links to our Q&A and other fact sheets, and we certainly encourage you to share them with your networks.
Another question is whether or not someone can submit comments on behalf of someone else, and the answer to that is yes. There is an option to provide comments on behalf of a third party, and that's particularly helpful in cases where there might be perhaps an immigrant parent who doesn't want to submit their comment completely on their own, whether because of fear of like their own identity being discovered or because of language barriers, and that is something that can be done through the mechanism on regulations.gov and also through the user-friendly portal.
And in the rule, it does stipulate that comments need to be received in English.
Yeah.
And while that is not something that we are supportive of, we want to make sure that everybody's comments do get reviewed. So if you are working with someone who speaks a language other than English who wants to submit comments, and you want to include the original comment and a translation, we encourage you to do that, but to please make sure that the translation is included.
We also have a question about whether this affects all immigrants, legal versus illegal, is the question that was posed. This applies specifically to immigrants that are seeking to migrate through legal means, usually through the family-based system. So those immigrants who are seeking to apply for admission to the U.S., as well as those who are already here lawfully and are applying for a green card. So this public charge test is only applicable to those specific types of immigrants.
Someone's asking whether or not we can provide an overview of text to share with families in your program. So first of all, thank you. I'm glad that you are looking for information to share. We will make sure that in the resources that go out that the talking points for working directly with immigrant families are included in there. In the meantime, I think the important messages to share with families are around the fact that this is a proposal, that nothing has changed. We want to let families know that they can take action and fight back, that they can submit public comments. And we also just want to make sure that families know that right now accessing benefits can help their family and that there is no reason right now to withdraw or disenroll from programs. And we'll make sure that we share those talking points.
There's a question about whether or not comments can be handwritten and mailed in. Actually, I know that there's absolutely an option to mail comments in on whether, I think they can be handwritten too. I don't think they need to be necessarily typed out, but legible would be ideal.
There's a question about TANF childcare. Many of you know that childcare assistance can be funded in multiple ways. Direct cash assistance through TANF is considered a public benefit that would be considered under public charge. TANF-funded childcare benefits are not included in this proposal. Neither is childcare funded through the Child Care and Development Block Grant, Head Start programs, or early intervention or other early childhood programs.
There's a question about whether or not we have resources to explain this to immigrant families in different languages, and we do. We have an FAQ right now in Spanish that is being translated into other languages. I actually don't know off the top of my head the status of that, but those will be posted as well on the Protecting Immigrant Families website. Do you know of a source where we can get state-specific information about numbers of documented versus undocumented children enrolled in TANF, Medicaid, or SNAP?
So on this question, I mean, one of the big issues here is that when we're talking about young children, the vast majority of young children are U.S. citizens, or a smaller share who are legal, have some kind of lawful status. These children are eligible for benefits as any child in this country, and states are not and should not collect information on the immigration status of parents when children are enrolled in these programs. So there's certainly not data on that. I think that it is there is data on children in immigrant families as a share of children overall in communities. We do have numbers of the number of children who are living in a household with an undocumented family member, also children who are living with parents who have some form of lawful immigration status. I think all of that local and state data can be relevant to making the case that this rule would have widespread harm, in particular on citizen children who are living with in immigrant families of all different statuses. But again, this proposal in particular is targeted towards hurting immigrants who have lawful status and are looking to achieve long-term residency in this country.
Right, and so just to reiterate that the children who would have to go under the public charge test themselves are ones who are immigrants who are lawfully here applying for a green card, as some children have to adjust their status as well, just like their parents do. And then I'll also just once again flag that on the protectingimmigrantfamilies.org website, there's several resources from recent research that's been done on the impact of the proposed rule that has, and there are some of those resources that have been broken down with state by state data. There's a question about how many people this rule will impact directly. Is there an estimated number? There's a couple of different analysis there's a couple of different sets of analysis that have been done on this to look at, like the number of people who adjust for lawful permanent resident status every year. That doesn't take into account people that are seeking to migrate here. I think there's also an estimate that the Department of Homeland Security put out that was we think very much an underestimate, because it just looks at the number of people who would adjust to LPR status in 1 year. We think that the more accurate number is the one that, in terms of like the overall chilling effect, and the one that we should really be focused on, because we know that this will have I mean, it may be indirect, but really direct in terms of the harm, is that chilling effect that would get at 26 million individuals, including the 9 million children living in immigrant families. We just got another question about whether public charge would, the test, would it affect those individuals applying for citizenship? And once again, that is, it does not apply at all at the point of when an individual is applying for citizenship.
So we also have a question about whether or not there are legal actions that can be taken to support children who are denied services. So I think, we should, again, as advocates and for those working directly with families, if there are incidences that you're aware of that families are being denied benefits for which they are eligible, that should absolutely be brought to the attention of folks in your community. So helping that family to access legal assistance, but also raising questions with whether it's a state human services agency or a locality. We would like to know about those issues if they are coming up in communities. So I'm sure that there are also local partners who work on issues related to immigration that would be good to involve in those individual cases. So someone wants to know about whether or not there are organizations in their area working on this issue that they can connect with, which is a great question because, yes, the Protecting Immigrant Families campaign is now in 30 states. So if on our website, the Protecting Immigrant Families website, there is an overview of the campaign, and actually I think it's on the main page of the website now. It lists all of the active members of the campaign. So we do encourage you to look at that list and to find the organizations that are active in your state and to connect with them. And they will likely also be working on a public comment strategy for networks in the state. So I think connecting with them is a way to really amplify our efforts. So thanks for asking that question. So we have a question about how to talk to families who don't have immigrant backgrounds about what this is and why they should comment. That is a great question because certainly just the term public charge is not likely to resonate with folks, and we recognize this is a pretty hard issue. But I think this is again why it's so important and why the early childhood perspective is really important. Is that I think it is very possible to again, and I would use that fact sheet that we have on the impacted children to talk about what the long-term impacts are of children living in families that are destabilized economically, to live in families where they don't have enough support for their health and nutrition needs. And we, again, looking at the numbers and knowing that 1 in 4 young children in this country lives in an immigrant family, it's really important to let people in your community understand the long-term impacts of that. So these are children, these are the future of our country. These are kids who will soon, be students in our schools, will be future workers. They will be the future people who we need to be doctors and nurses and lawyers and teachers in this country. So I do think it's really important to send a message to folks about the impact that this will have on children's development and that those adverse outcomes really have lasting effects into adulthood. Another question related to the same question. So again, I would encourage you to check out the Protecting Immigrant Families website because we have there are a number of resources that put into plain language what the impacts would be, both on overall health and wellness of this country, but also the overall impacts on how it would really change immigration in this country. And again, just to reiterate the points about really closing the door to people with less means and making this a country that really looks at wealth as an indicator of whether or not people can settle here long term. So a lot of that language is on the Protecting Immigrant Families website and is a good starting point to talk to people in your communities about this. So we have a question about multiple comments being written separately and then sent together. I don't have a lot of experience with the mail-in option, but certainly if they are written individually and they are individual unique comments, then I would imagine that the federal government will need to read each one of them. They won't count as one comment, they'll count as separate comments. So it seems like that strategy would be perfectly fine to bundle and send together.
We have a question about whether this rule would lead to deportations and separate families that way, or is that not a major risk? There is already there's already rules under existing guidance under public charge that in certain instances an individual could become deportable if they were to use public benefits, and there's really specific it's a very specific rules around how that would happen, and it's actually very rare and almost never happens, and would require like the state to actually go like go to court and like sue the individual to get compensated. So there is this clause that's very, very rarely used. So there is no language in this proposed rule that would impact deportability. However, we did want to flag that there is a potential for a parallel rule to come out of the Department of Justice regarding public charge and deportation. We don't have any idea of when that could potentially come out. But once again, if there was something to come out on deportation grounds and public charge, there would have to still be, once again, a comment process, and we haven't heard anything about that coming up anytime soon. There's a question about if we have any resources about how this rule may end up funneling kids into child welfare. And I think, we have, there's not any specific resources on the child welfare system specifically, but I do think it's worth highlighting that because any kind of reduced access to benefits creates instability in a family, that it could create additional hardship for that family, which of course increases the risk of entering the child welfare system. And given that immigrant families, documented and undocumented alike, have been under incredible stress under this administration, any additional attack that creates more hardship for a family creates additional risk for entering the child welfare system, and also has a range of other harmful impacts on their educational attainment and overall well-being, their economic security, and health and mental health.
And I would just add, if there is a particular area like child welfare that you work in and would want to submit comments on, that, again, going back to the sector strategy, there will be comments that are written from a child welfare perspective as well as others. So please feel free to reach out to us. We'll share our contact information before we close out, and we can make sure that you get all of the help that you need in terms of writing comments. And somebody wants to know what the hashtag is. The hashtag is protecting families. Protect families. Protect families. Somebody wants to know about a specific place in the regulations which talk about which benefits are not included. So I will follow up on that specific request on the page number offline, but I just want to reiterate again for folks to understand that it is just the benefits that are in guidance now, so the cash assistance and the long-term institutional care that are considered as public charge now, and the addition of Medicaid, SNAP, Medicare prescription subsidies, and housing assistance that would be in this expanded definition of public charge. And if the program that you're thinking of is not one of those, then it is not included in this proposal under public charge. And this is very different from earlier versions of the proposal, which is why we know there's a lot of questions about this, because we did see in leaked earlier versions a much, much longer list of benefits, and those did not end up in the published version. So somebody wants to know whether or not in their public comments they could mention that parents are pulling out of early intervention services, even though EI is not a part of the proposal. So in fact, we think this is a really good example of the kinds of widespread chilling effects that we are already experiencing and believe will increase under this proposal. So even though we're asking you to not, the guidance on not listing programs that are not included is not meant to say that folks shouldn't give examples of families that are disenrolling from programs or fearful of accessing programs or any changes that you've seen in terms of families' participation. We just don't want you to explicitly say, please don't include early intervention under public charge, right? We don't want to give cover to add programs to the definition, but absolutely examples of how these programs are being impacted by families is very important to include. So I think that concludes our questions. If you go to the next slide, please, you have our contact information. Please don't hesitate to reach out with additional questions, and in particular, if there is support that we can provide in helping you to write those public comments, if you have questions about the comments that you're writing, we are happy to help. So we look forward to staying in touch, and just want to thank you again for all that you're doing and for including this really important issue among all of the priorities that you're working on. So thank you for taking the time to join us today, and thank you for submitting your public comments by December 10th. Have a great day.